every Monday starting at 5 p.m. They need to feel worthy.
From the Sunshine State, this is Tampa Bay's Tan Talk.
It's time for FLA Law, brought to you by the personal injury attorneys of Perenich, Caulfield, Avril Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Good evening. It is Tuesday evening, and that means we are here at the studios for WTAN for FLA Law on the Radio. This is a live legal call-in talk show put on by the law firm of Perenich, Caulfield, Avril Noyes. We are the oldest personal injury law firm in Tampa Bay. We have been helping people injured in car accidents and other personal injury matters since 1955. A way to give back to the community is by putting on this show every week from 5 until 6 on Tuesday to be here to answer questions that you may have regarding the law. I am Matthew Noyes. I'm one of the partners of Perenich, Caulfield, Avril Noyes. And so I'm here to answer any questions you may have regarding car accidents, car insurance, workers' comp, being hurt at work, or even Social Security disability. I can answer those questions for you. But I also have a friend and a colleague here. It's Dennis Moses. Dennis Moses is here too to answer questions that you have regarding his specialty of law. So Dennis, can you introduce yourself to our listeners and tell them what areas of law that you're going to be here to answer questions for?
All right. Thanks, Matt. Appreciate that and appreciate the invite. My name is Dennis Moses. I'm with the Pippin Law Group, a firm that was started by Joseph Pippin. Many in the area know the name. He started his practice in the area of wills and trusts back in the 70s.
Yeah.
Long time ago. Unfortunately, he passed recently, but we're still plugging along, keeping the firm the way that he would want to keep it. So what we specialize in is wills, trusts, probate, elder law, Medicaid, that sort of thing.
Yeah, and so if you have any questions regarding those areas of law, give us a call. Dennis is right here. I've known Dennis. I did the calculations on the way down. I have known Dennis for almost half my life now.
Wow. That must mean we're getting old.
Or I'm very young, and we've only known
true.
each other. I've only known you for 5 years. No, Jesus. Dennis and I went to law school together, and we've been friends and colleagues ever since. And so it's a pleasure to have you, Dennis. It's good to see you. It's sad that our lives are so busy that it takes a radio show for us to get together.
Well, whatever it takes.
Yeah. So
and we enjoy doing this. So.
Yes. And Dennis has done a radio show for the Pippin law firm as well.
Yeah. In fact, Joe Pippin had the longest running radio show in Florida, 37 years.
Yeah, I remember the times that we would go to Polk City. I think it was Polk City, right? You and I would go to Haines City.
Yeah, a little trailer.
And do the radio show together. That's like our firm used to have FLA Law on the television. And I think Joe Pippin was the guest who appeared the most often.
Yeah, that was a great show.
Yeah, and that was a TV show, and so it's same kind of setup. We were there to answer questions and invite smart guests like yourself to answer questions, and so that was very good. And so we wanted to continue that tradition by doing it on the radio instead, since they don't do live TV anymore. So if you have a question, give us a call at 727-441-3000. That is the law line. Again, it's 727-441-3000. Give us a call with your question regarding any area of law. We do personal injury. Dennis does estate planning, wills and trusts, elder law. But between Dennis and I think we can probably tackle any question that you may have regarding the law, or at least give you direction to where you need to go. So you can call us on the law line, but you can also reach us on our live feed on Facebook. We are on the firm's Facebook page at Perenich, Caulfield, Avril Noyes Injury Lawyers. You can see us here hosting the show right here. You can type in your questions under the comments, and we'll be happy to answer the questions that you have through Facebook as well. So give us a call before all the lines fill up or we run out of time this evening. But Dennis, before we get started, I mean, we talk about wills and trusts, but it's really estate planning. And can you tell us what the most common mistakes are when it comes to estate planning in the state of Florida? Welcome to hurricane traffic. Hurricane notices. That's no problem. That's just to let you know that's just to let you know that there is a hurricane.
I heard that somewhere.
So, but this is a good break from listening to the weather. You can listen to FLA Law on the radio.
And that thing was turned off too.
I think they turn on even when you turn off.
I guess so. I just learned that.
No problem.
Yeah, the most common mistake is people do absolutely nothing. And, in terms of planning for the distribution of their estate upon their death, there's a variety of reasons people do nothing. But a lot of people just don't want to think about it, or they think they're too young, or they're not sick enough, or whatever. I'm not in the hospital. It's just amazing how many hospital runs I make and nursing homes. And, that's not the time to be talking about estate planning. The time to talk about estate planning when things are good, when we can think about these things before we get too old, where we really can think about these things. So if I can just put, one condition out there, if you don't have your affairs in order, you really ought to do that, whether it's with me or anybody else that does estate planning.
Because this is the time to do it before crisis occurs.
And when crisis occurs, most people don't want to think about this, but, if you don't do anything, the state of Florida will write your will for you. And it's not a very good will, not a will that most people would choose for themselves. So, if you have particular ways that you want your estate handled, you really ought to see an estate planning attorney.
Yeah, and we're going to talk more about estate planning because a lot of people think that estate planning is just wills or trust, when in reality, it's a whole bunch more than that. But before we even delve into the power of attorneys and such like that, why don't we tell our listeners a little bit of the difference between a will and a trust and how that comes into play under Florida law?
Sure, Matt. The differences between wills and trusts, number one, with a will, there's probate associated with it. And probate costs vary from 3 to 10% of the estate. And so, some people might say that I don't have a very large estate. Others may say that they do. But no matter what the size of the estate, if it has to go through the probate process, it's looking at a few $1,000s. And, I always tell my clients, or if I'm speaking somewhere, who's the first beneficiary in the will, whether he's named or not? It's probably the attorney, because the attorney is going to take the fees off the top, and when all that can be avoided. So, we got the probate costs, 3 to 10% costs, 6 to 14 months to go through the whole process. It's a very lengthy court process if it has to go through the probate process. We have to petition the court. We have to publish in the paper. There's all kinds of things that we need to do when all that can be avoided. So then the first disadvantage of having a will, there's probate associated with wills. Probate costs an awful lot of money, takes an awful lot of time.
And isn't it public? People can see what's in your will.
Yeah, so the second disadvantage of having a will, wills are a matter of public record. What does that mean? Well, if somebody died that you can go down to the local courthouse and pay the clerk a couple dollars, and you can walk out with that person's will. So, there's no privacy associated with wills. Everybody can see what's going on, who's getting what's going where. So the second disadvantage of having a will by itself, wills are a matter of public record. And the third disadvantage, with a will by itself, you have no guardianship plan in place. God forbid you were to become incapacitated. Wills only take effect when we die, do nothing while we're living. But with a living trust now, the estate has, you have a built-in guardianship plan because you choose successor trustees to step in behind you. So if I have a living trust, which I do, I name successor trustees. So if I were to become incapacitated, my successor trustee can automatically step in as the trustee of my trust, pay my bills, manage my assets, do the things that I'm used to doing for myself. And the process to make that happen is that the trust document actually calls for 2 doctors to determine that a person can no longer, take care of their financial affairs. Then with those 2 doctor statements, the successor trustee can automatically step in as the trustee of my trust and do all those things that I was used to doing for myself. So 3 disadvantages then of having a will. The first one's probate. The second one's no guardianship plan associated with a will by itself. And the third disadvantage, wills are a matter of public record. So how do we turn all those negatives into positives? Well, that's when we
Good
talk about
question.
living trusts.
Yeah. Okay. What are the? So it sounds like there are many advantages to having a living trust as opposed to having just a
will or no estate plan at all.
Yeah. Certainly, a plan is better than no plan whatsoever.
Exactly. Even if it's a will.
Yeah. And so what are the key advantages to having a living trust as opposed to just a will?
Yeah. So the first advantage of having a living trust, then we could eliminate probate. All those attorney's fees, all those court costs, hard costs, all basically gone. And the time that it takes to settle the estate, much, much less. In fact, I've seen many estates distributed, settled over, and done with just a matter of days. Why put your families in a situation day in, day out, going through the courts, working with the attorneys, when all that can be avoided? So then,
avoided by having a living trust. So
correct.
Okay.
So the first advantage of having a living trust, then we can eliminate probate. Second advantage, back to guardianship planning again. With a living trust now, we have a built-in guardianship plan because we choose successor trustees to step in behind us. So again, our successor trustee can automatically step in. If we can no longer do that, it doesn't take a court order, it doesn't take a court process in order to do that. It's automatic. And then the third advantage, remember, wills were a matter of public record. Living trust, the estate is privacy. Nobody's going to see what's going on in our estate except those that we want, our successor trustees and our beneficiaries. So, wills work fine, but will the living trust work for a whole lot of people? Most people, absolutely.
I've heard people are concerned about trust because they have the misconception that they lose control over their assets if they put it into a living trust.
Yeah, I hear that all the time. But what we're actually talking about here this afternoon is a revocable living trust. That means that everything still belongs to us. We're still in total control of everything. Nothing's changed. People don't notice that anything's different because we just carry on just like we always did.
And you're in charge of
how you're in charge. Absolutely.
Until you reach a part of incapacity
or death.
And it takes 2 doctors to have you be determined to be incapacitated.
Correct.
Before you lose control, so to speak, of your assets.
But still, the assets are for that person that becomes incapacitated. The successor trustee cannot use those assets for any other reason.
Okay. Yeah. So it sounds like it's beneficial so much, not because the will only comes into play when somebody dies, but the trust can be active from day one all the way until the death and more.
That's correct. But you got to keep in mind that having a living trust is a 2-step process. The first step is that we got to create it. The second step is that in order to make it work right, we got to fund it.
Okay. Explain that.
Yeah. So what does that mean? Well, there's certain assets that we actually own that needs to be retitled to the name in the trust in order to get the benefits. So what assets need to be retitled and how do we do it? Well, our home. Some people have a couple different homes, maybe one here in Florida, one in another state. What happens when that person dies? Well, there's actually 2 probates, one here and one in the other state because real estate's probated in the state in which it is situated. But by deeding both homes in the trust, we can eliminate probate everywhere. So how do you get the home in the trust? Well, if you have an attorney prepare your trust, the attorney will do that. And then the deed's filed, with the county. And now if you look up the property appraiser's records, you'll see that the house is in the trust, but you don't lose homestead exemption. You don't lose your creditor protection and all of that. So it's important, that the homestead and any other properties that's in an individual's name gets retitled to the trust. Well, what else goes in the trust? Well, stocks, bonds, mutual funds, brokerage accounts. So how do we do that? Well, if you have a financial person that you use, you just contact them, tell them you got a living trust. They'll know exactly how to retitle the accounts into the name of the trust. Bank accounts, checking account, savings, money markets, CDs, all of those accounts need to be retitled to the name of the trust. So how do we do that? Well, you just take your trust agreement over to the banks that you use. They'll copy what they need out of the trust agreement, and they'll go ahead and retitle all those bank accounts to the name of the trust. So, it's no good just to get a trust without putting anything in it.
Right, and it sounds like it's a lot of work.
But it's really not.
How
many banks does a person usually use?
Right, and if you don't do it, and if you don't do it then, your family is going to have to do all that work after you're dead while they're mourning your loss, trying to figure out which bank accounts there are, the homes, all having to go through probate. Am I right?
Yeah, you're correct.
Okay.
And but there's a second document that goes with the living trust for just what you're saying, Matt. Say there's an account that should have been in the trust, never got to the trust, and that person dies. Well, we include a pour over will in the estate planning documents, so that what happens then, well, if a person dies and has that pour over will, when that person dies, that asset, that bank account, that whatever account it happens to be, would actually pour over from the will. It'll get to the trust where the trustee has access to those funds. But in order to go through the pour over will, that asset still has to go through probate. So that's why it's very important when a person's still living and healthy and able, that get everything that belongs in the trust there, so that the will's only used for personal items and vehicles, and there's no probate on those. So vehicles don't need to go into the trust.
Okay, that's very helpful. If you have questions, again, we are a live legal call-in talk show. So we are live. We are legal.
Are we live?
We are live, and we are happy to answer your questions. All you have to do is call in, and it's 727-441-3000, or jump on Facebook on our live feed at Perenich, Caulfield, Avril Noyes Injury Lawyers, and type in your question there, and we'll be able to answer questions that you have from Facebook as well. Now, Dennis, we talked about terms, and I heard living trust, and I heard will, but there's another term out there called a living will. What is a living will, and how is it in relationship to a will and a living trust?
Yeah, that's another document that we include in our estate plan. I hear a lot of people say, oh yeah, I got a living will. Well, what they mean, they got a living trust. A living will is different. The living will basically says if a person comes down with a condition there's no cure for. The living will basically says if a person comes down with a condition there's no cure for, they've done everything possible that they can do. Rather than keep them on life support, the healthcare surrogate can make the decision at that point in time to go ahead and remove life support after they tried everything.
Okay, thank you. And so the living will, it has more to do with life support and extending life.
Correct. And
nothing to do with assets.
Yeah, and I get a lot of confusion. Well, I already have a living will. My doctor gave me one. Well, that's not a living will. There's a couple differences. That's a DNR, do not resuscitate, and that's a yellow form that a doctor signs and fills out. And the difference is with a DNR, do not resuscitate, say a person had a series of strokes or a series of heart attacks, basically really in bad shape. So the doctor issues a do not resuscitate. That means basically, all right, if that person has another one of these strokes, another heart attack, whatever, don't do anything. Don't even send the paramedics out. Just let me go.
Perfect.
And I see so many people that say, well, I already have that. I said, my first thing, I said, you perfectly look healthy. Are you terminal? No. Well, then why do you want a DNR? What you want's a living will. All right, the difference is I have a heart attack. Call the paramedics. Do everything you can to get me back. Take me to the hospital. If I need surgery, do that. The difference is if they did everything they could for me and basically just left me in a vegetative state, for all practical purposes, there's no life, nothing else they can do, no chance of recovery. Then after they tried everything, just go ahead and let me go.
Yeah, we're going to go a little bit more into that, but let's first take Peter's call. Peter, thank you for listening, and thank you for calling in. How can we help you today?
Hi, I have kind of a simple question. Are there any negatives behind doing I've heard like if you do a 1031 and it's, you can do it without, but if you go ahead with a trust and you try to do a 1031, there might be some issues. Can you speak about that maybe a little bit?
Sure, Dennis.
What are the negatives?
Well, with a 1031,
What is a 1031 first for our other listeners?
basically you're selling a property, you want to buy another property,
Okay.
and you don't want to capital gains, that sort of thing.
Okay.
Um,
I'm
but
so
I
glad
understand.
you're here because I had no idea what that was.
But I understand that you got to wait a period of time. I think it's generally a year before you can actually put that property into the trust in order to, avoid the penalties. But in general, the negatives of the living trust is just for the attorneys. They're not getting all those probate fees. But that's about the only negative. There's only positives really associated with having a living trust.
Okay, so that only negative was what again? I didn't catch that. I'm sorry.
If you buy the new property, sell the old property, buy the new property, I don't believe that the rules allow you to go directly into the trust, take title to the trust. You got to wait a year or whatever that period of time is.
I see. Okay.
But at some point in time, it needs to be done, though, to avoid probate.
But the disadvantage to the trust is not really to the person who's creating the trust. It's a disadvantage to the lawyers who do the will, because the person who created the trust avoids having to pay the attorney the probate cost.
Yeah, and the disadvantage to the family is that, they got to go through all that process, all that time, all the money, when all of that could have been preserved for them.
Yeah.
And so.
Okay. Yeah. Great. One other quick question. What do you think a not really a complicated trust should cost?
Well, there's a good question. I can tell you what we charge. Different attorneys charge different amounts. But if we do a trust package, say for a married couple, we do the joint trust for them. We include the pour-over wills for each. We include a durable power of attorney for financial, for healthcare, new living wills, and the package price includes us deeding the homestead into the property, which you'd be looking at $995. For a single person with all the same documents, it's $895.
Okay.
So
I thought it'd be better than that for a single person, because that's the only benefit we get is being single.
Oh, some say there's a lot more benefits, so I don't know.
Only $100. Oh, there's way more benefits than that.
I tell the guys that's all we're worth. We're only worth $100.
It depends who you ask, but yes.
So that's
okay.
right.
Yeah. All right. Great. Nice listening to you guys, and keep it up. I'll continue on, and be sure to let me know how I can get in touch with you.
Perfect,
right.
Peter. Thank you very
Thanks
much
for listening, Peter. Appreciate it. Good question.
All right. That sounds good. Brandy, thank you for listening, and thank you for calling in. How can we help you?
You said Brandy?
Yes.
Yes. Okay, I have a weird situation I'm working on. I have a friend that her sister just passed away a month ago. Her mother is 100 years old, and her sister is in Pennsylvania, so she can't help at all. So there's no other relative, just a sister and a 100-year-old mother.
Was there a will?
No. So we're going to a probate attorney. Well, we're looking for a probate attorney. We've had a lot of trouble finding one. She did have a car that was completely paid for, and somebody said that we should get it registered in her mother's name, and then she could sell it. But we haven't been able to sell it because we didn't know.
Yeah, so the person that passed away did not have children?
No.
Yeah, so according to the Florida statutes, if somebody dies without a will, it's called intestate. And what happens, the statutes dictate what the will should be. And first of all, if a person has children, the estate goes to the children. If there's no children, then it goes back up to the parents. So mother's still living, so she'd be the natural heir. But assuming she was not living, then it would go down to the siblings and down, to their children. So it would be everything would go to the mother.
Would go
So
to the.
do we go to
And you
So
can
we
go to
go
the
to the-
DMV and
and get this registered to her mother first,
correct.
or can we do the sale already?
It would need to go to her first.
Yeah, so you would have to go through the court system to go through probate.
Oh, you ought to be able to do that yourself.
Right. That's what
Yeah.
I was thinking. You can, because it's an intestate, and if it's just one piece of one asset.
Yeah, were there other assets?
Oh wow, you're breaking up.
Did your friend
More.
have other assets?
Has she got other assets?
Yes.
Correct.
Does she?
Yes, she has a house.
Okay.
Okay, well, that's going to have to be probated then if the house is just in
Yeah.
her name alone.
But as far as I know, only her house and her car. Is
Okay,
her
well,
asset.
also the car can, if there's going to be a probate anyway on the house, the car can be included with that in the petition.
Well, we don't want it. We want to go ahead and sell it. I mean, to pay the attorney.
Well, I understand that. But, if all she had was the house and the car, and that was her primary residence, right?
Right.
And there were no creditors?
No.
Yeah, so, the attorney can actually do a summary administration, which is a lot quicker, which is a lot faster, which is a lot cheaper than going through a full formal probate administration. So, and, that can take maybe 3 weeks or so. So you're not looking at a lot of time there.
Summary administration?
Summary administration.
Okay, I got to ask you one thing. I kind of got in this. I was changing channels on my radio and caught you talking about it.
Sure.
I didn't catch what company you are.
Well, that's perfect. I'm going to let Dennis. This is Dennis Moses. I'm going to let him but give his contact information because he is the trust and estates and wills estate planning attorney. So, Dennis, why don't you tell all our listeners how they can reach you if they need to get in contact with you?
Yeah, my name's Dennis Moses. I'm with the Pippin Law Group, a law firm started by Joseph Pippin, who very well known in this Pinellas County area. I'd be happy to talk to you. We don't charge for consultations or anything. We do everything on a flat fee basis. So, our clients know exactly what it's going to cost, and it's up to them if they want to proceed or not. But our telephone number is 727-586-3306.
3306?
586-3306. That's correct.
Okay. Can I call you tomorrow morning?
I'll be there tomorrow morning. Lord willing, and the hurricane doesn't get us.
That's right. No, but
We shouldn't be here by then.
no, that's right. And that's something that you don't see too often with estate planning is the free consultation. I know in our personal injury practice, we always do free consultations, but Dennis is one of the few that I've known that does free consultations with estate planning as well, or wills and trusts.
Well, Joe Pippin has always done that, so we're continuing to do that.
Yeah. So I'm
Okay,
sure.
so what is the name again?
It's the Pippin Law
The name of
Group.
the attorney?
Pippin,
It's Pittman Law Group. And your name?
Dennis Moses. You can remember me, Moses, just like the Bible.
Got it.
Yes.
You talked to
I'm gonna
Moses
call you
today.
tomorrow.
Yes,
All right.
we appreciate Dennis is a great help, and I'm sure that he can guide your friend and her family the way that needs to be. But that's a perfect example of what failure to plan causes this friend trying to help out.
That's correct.
And the 100-year-old mother,
Is she competent, by the way?
I don't know if
Yes,
she's
she is. Very
That's
competent.
good, because she would be the one that would need to sign the petition and everything.
yeah, and so she wouldn't have to worry about all this had there been a will
Correct.
Already
A
taken
living
care
trust
and a living trust.
It's a petition.
for summary administration.
Yeah, but Dennis will tell you all about that tomorrow if you call him. What's the number again?
727-586-3306.
Thank you very much, Dennis.
All righty.
Thank you for listening.
Enjoyed talking to you.
Thank you, guys.
Sure, I'm glad we were able to help. So you talked about summary administration and a formal administration. Can you briefly tell our listeners the difference between those?
Yeah, in Florida, if an estate is less than $75,000 in probate assets, we could do the summary administration, but there has to be no creditors. Nobody can be owed any money. If that happens, the judge is going to kick it out. And we can include a homestead because that's a non-countable asset too. So, if a person has less than $75,000 in accounts, say other assets besides the home, we can include the home to do that. And we can also include a vehicle. And again, that's a lot quicker. It's a lot less costly than having to open up a full-blown estate, which in Florida, that's called a formal administration. And that has to go through a lot more hoops. And that's the one that costs, all that money. That's the one that takes 6 to 14 months or longer.
Wow.
So, especially with estates over $75,000, And if the person has a home, they may say, well, I don't really need a trust. Well, just probating the home, will be a few $1,000s, for a few $100s on the front end. We can eliminate all of that on the back end.
Right, and save the hassle and the headaches and the added stress that you already have once a loved one passes away.
Correct.
So the living trust is such a good way to take care of it. Before we took Peter's and other callers, we were talking about another way for estate planning and talked about power of attorneys and such like that, and we were talking about the living will. There's also a designation of healthcare surrogate. Is that a form that?
Yeah, that's very important.
I've heard about that. Can you explain what that is and why is it so important?
Yeah, so that's the last document that we include. We include the trust, the pour-over wills, the living wills, and the other document, which is probably the most important document, would be a durable power of attorney. And in Florida, some people think that power of attorneys only go into effect when somebody becomes incapacitated. Well, that's not true. A durable power of attorney is good as soon as that person signs that document, and it's very powerful too. So, you need to make sure that you got the right people in the right spot. That's designated as power of attorney. So what does the power of attorney do? Well, if a person becomes incapacitated, cannot make financial decisions, or even if the person's not incapacitated, once the person signs it and you give that document to somebody else, who is the power of attorney, they can take that and become that person. So I usually advise my clients, don't give that document to anybody. Just make sure your power of attorney or your successor trustee or your executor knows where you keep everything and has access to those documents, and then they can see what kind of responsibilities they have at that time. But the power of attorney can make financial decisions, handle bank accounts, investments, sell a house, sign your name, complete financial authority. Plus, in our power of attorney documents, we include health care. If the person can no longer make healthcare decisions for themselves, the power of attorney can do that. And also, we have a pre-need guardian provision in that power of attorney, which just means if a person ever determines that they need a guardian for whatever reason, that person's choosing who they want to serve in that capacity now, rather than a court or a judge or anybody else making that decision for them later. So wills take effect when we die. Power of attorney documents are only good while we're living. But those are the 4 documents that most people need, and they're very important. What if somebody doesn't need a trust? Well, there's 3 documents that person should have. Again, a will. Will takes effect when we die. The durable power of attorney is only good while we're living. And then a new living will, don't keep us on life support if there's no life, that sort of thing.
So helpful, so important to have too, because especially the designation or letting the family know who's going to be the one making the decisions, the power of attorney, because it eliminates the fighting. In essence,
it's just amazing. I've been doing this now for 27 years, and people come out of the woodwork, turn families against each other because there was no plan or they didn't like the way the plan was written. And, a lot of people ask me, well, what can you do with a living trust? Well, you could basically do just about anything. I had a lady come in once, she was 97. And she said, well, I guess it's time to do something. Well, I said, it probably is. But, she was a good 97, a lot of energy and everything. Yeah. And she said, this is what I want to do. I want to give my nieces, nephews, and all these distant relatives. And there was probably 20, 30 people she wanted to leave to. And then she said, well, I want to make sure that nobody gets anything till they turn 65. And I kind of looked at her and she says, well, what's wrong with that? I said, well, actually, it's nothing's wrong with it. They're your assets. You can do whatever you like with them. And she said, well, my rationale is that, well, I want these people to work hard during their lifetime. And then when they get ready to retire, I'd like to leave them supplemental retirement. Well, when you think about that, that's kind of nice.
Right.
Another situation, a couple have 2 children. One's great with money, one's not great with money. So what do? We create a trust, the one that can handle money, give an immediate distribution outright to that one, and then put the other ones out over time. So, they don't spend it all at one time.
And you can't do that with the will.
You could do that with the will, but the whole thing's going to have to go through probate.
Then it turns into a trust anyhow. So you're paying the cost of the probate only to create a trust
much easier,
afterwards.
less complicated way as a living trust. And so in the instance of the 97-year-old, she came in a year later. She says, you know what, that was a lousy idea. She said, let's just go ahead and give everybody everything, when she passes on. So what do? It's easy. We just do an amendment to the trust. Boom, it's fixed.
Oh, that's wonderful. So it doesn't take a whole bunch.
And also, too, people come to me, they have a special needs child. Well, what can we do on that in that situation? Well, if they get an inheritance, that's going to kick them out of receiving their government benefits. But we can create a special needs trust within the living trust so that, whatever inheritance that person gets, whatever that person receives, won't interfere with any kind of government benefits. That is just to be used for anything over and above, what the government benefits would do.
That is very helpful, because we see that way too often, that in our business, in personal injury business, we have people that are on government assistance, and then they recover for an auto accident or something, and their net settlement can result in them losing their government benefits.
Yeah.
So that's why a special needs trust is so important. So you are listening to FLA Law on the radio. I am Matthew Noyes. I'm one of the partners at the law firm of Perenich, Caulfield, Avril Noyes, personal injury law firm serving Tampa Bay since 1955. And with me is my good friend and my colleague, Dennis Moses. He is a estate trust wills estate planning attorney throughout Tampa Bay, quite honestly. I mean, you're Zephyr Hills and in Largo and throughout the whole Tampa Bay area.
Yeah, I handled Zephyr Hills, Largo, Lakewood Ranch, and Trinity.
Yeah, so they keep Dennis very busy, and so it's really good. But Dennis is here, and I am here. Matt is here for at least another 18 minutes to answer any questions that you have. So give us a call on the law line at 727-441-3000. This is far better than listening to the weather that says the same thing about the path of the storm, because there's no different changes to it. So listen to us on FLA Law on the radio, and we'll
just make sure you're prepared and you stay safe.
That's right. You do got to stay safe. But in preparation for today, I did ask my staff, my people in my office, and I said, listen, if you had an opportunity to ask an estate planning attorney one question, what would it be? And so I'm going to ask a few of these questions.
So we're going to be here another 2 hours.
Yeah, we could be. Yes. The first question that was asked was, my husband and I are a couple in our mid-30s. Both are employed. We have no kids. We're mostly paying off student loans and have a mortgage on our first home. Is this a good time to think about making a will? If not now, when? If so, when to renew it?
Well, a good time to be thinking about an estate plan is when somebody turns 18. Because at 18, that person becomes an adult. And if there's medical issues and, a parent wants to get medical information on the child or whatever, many times the parent can't because they didn't designate a healthcare surrogate. So I always tell young people, well, two documents you should have anyway. You really don't have any assets in the estate at that point. You should have the durable power of attorney. So, if that child were to become incapacitated in an accident or whatever, there's a designated healthcare surrogate and somebody can make medical decisions based for that person. And then a living will, God forbid it ever came down to that, that life support can be removed at some point. Once you put a will together, when you start developing assets, usually the younger the better. The most appropriate time is when somebody has children. I have so many young people that say, I don't have anything. Well, you got 2 children, 2 minors, right? Aren't they the most important to you?
Yeah.
So in the will, we actually put guardianship. God forbid the parents die. Who's going to raise the children? And that's probably the most important time to actually get an estate plan, to get at least a will put together.
Yeah. And they're recently married, and so when you get married, isn't that even a time to?
That's even a better time.
You better, and even if you have something in place, you need to.
Yeah, life changed at that point.
Yeah, so you need to check the changes. And that leads me to, what if you had a will, that you created a will, and before you got married, and then you got married and you never changed the will, and you never mentioned your wife or your spouse in the will. Is that, and you pass away, what happens? Is the spouse, because they're not listed in the will, end up with nothing?
The spouse, according to Florida law, would receive something. If there's a home, and say the home's just in the husband's name, the surviving spouse will be entitled to a life estate, which means that that person can live there for as long as he or she lives. And then upon that person's death, it would go to, the husband's heirs. Or if they didn't want the life estate, they're entitled to 50% of the homestead. And also they're entitled to 30% of everything else.
I think that's the elective share. Is that
Correct.
what they call it? Yeah.
Correct.
So people think automatically, if I'm not, that you can carve your spouse out of your will. You really can't do
You really
that.
can't. The only way you can do that if you get a pre or post-marital agreement.
Okay.
Between the trust and a pre or post-marital agreement, the assets are pretty well protected.
How about in the trust document? Because you have all the power really to allocate your assets the way you want. In your passing, can you have in the trust, can you alienate your spouse should you desire to alienate your spouse and not leave anything to her or him?
Well, you can do that in the trust, but again, by Florida law, unless you have that pre or post-marital agreement, they're entitled to 50% of the home and 30% of everything else.
Even if it's not just in the probate, it's also in the trust.
Right, but
as
I
well.
have people that, for whatever reason, it always kind of breaks my heart, they're going to leave a child out. And I says, you can do that. But what we need to do in the trust or the will is just say, we're making no provision for this son, this daughter, for personal reasons, period.
Right.
Never give a reason, because once a person dies and say the reason was because he never called me on Father's Day or whatever, well, then the child will dispute it and it's real easy to contest it. So as long as we mention them that the person's not to receive anything, you can leave that child out or whoever out. And I always tell my clients, well, I hope we meet again, that things are patched up where we can get that child back in.
Yes. Well, that raises a good question about somebody contesting a will, or can you contest a trust as well, or?
Yeah, anybody has access to the courts.
Okay, who can contest, and what reasons why can't
Well,
they?
the trick is make sure that you do the document right. And I see so many people, they use LegalZoom or they do it yourself. Well, the problem with, doing it yourself, well, first of all, you got to do it right. According to Florida statutes, I've seen so many wills that's done. It would have been a lot cheaper just going to an attorney to begin with and try to fix that.
Oh, goodness.
But, you got to do it right. The signing needs to have special language in there in order for it to, pass through the courts. And if somebody does them themselves, how do we know that nobody's standing beside them with a gun or whatever and, saying this is what you got to do? An attorney, if they prepared, will document the files that, this person came alone. They were not influenced by anybody. This is their wishes as far as the attorney can determine, the person's competent, able to make decisions. But a very good reason for contesting is undue influence. And if that person can prove undue influence that somebody was actually making them do it, that's pretty easy to contest.
But I know, because you and I have talked, you take special steps to document that there is no undue influence and to remove any possibility of undue influence when you're doing the paperwork.
Yeah, if a child brings mom or dad into my office and this is what mom wants to do, she wants to leave me everything or wants to leave me 90% of everything, and immediately throw that child out. I say, you can't be here.
Yeah. Yeah.
And
then you have a heart-to-heart with the mom to make sure that...
Yeah, and then we generally reschedule the meeting because I don't want any influence at all. I tell the person, Mom, can you drive? If you can drive, you get here yourself next time. If you can't, you need to find another ride. But don't let this child bring you. That's another one that's really easy to contest.
Yeah, that's a way to protect you and your client.
That's what I tell them.
From fighting,
And if that's what mom really wants to do, I tell the child, well, it's protecting you too.
Exactly.
Yeah. So
from other people that may contest it.
Right, your siblings.
Right. So I think that's a good step to do. If you have a question regarding wills, trust, or estate planning, Dennis Moses is right here to answer the questions. We're here for about another 10 minutes. If you want to talk about car insurance, car accidents, work comp claims, or even Social Security disability, I'm Matt Noyes with the law firm of Perenich, Caulfield, Avril Noyes, and I'm here too to answer questions. Give us a call on the law line at 727-441-3000 or jump on our live feed on Facebook at Perenich, Caulfield, Avril Noyes Injury Lawyers. You can see FLA Law on the radio, right on Facebook. So it's a little bit of both. But Dennis, before we take the next call, let me ask you another question that was given to me by one of our staff members. I have a friend who lives with a guy. They have been living together for 20 years, and they have kids together. However, they've never been officially married. Even though they aren't officially married, what happens if he dies? Does Florida law recognize common law marriages?
The answer is no. Florida law does not recognize common law marriages. So I actually had that question today. Partner, girlfriend, passed away of many, many years, and the house was in her name. What rights does the husband have? No rights at all because they weren't married.
Yeah, and people don't think about that. I mean,
yeah. So if that's what you're going to do, and you have no intention of getting married, get your estate plan in order so that we can get it the way that you want.
Right. So I mean, if they had a will, if they had an estate, if they did any or trust, if they did any estate planning, that circumstance could have been avoided.
Exactly.
All right. I knew that answer. All right. Here's another
I've been doing all the talking. You can answer these.
I'm not going to answer this one. What is a ladybird deed and how does it work?
Ladybird. That's the name from the past.
Yeah. I didn't have no idea.
Most of you probably don't even know who Ladybird is. Lyndon Johnson's wife. She came up with a special kind of a deed. Because a lot of people, they say, well, shouldn't I just go ahead and deed my house now before I die to the children to avoid probate? And I always say, no, because what if mom or dad wants to sell the house or do something with the house? Now it's going to take the children, to all agree, and they're all going to have to sign a new deed in order to make that happen. So what Ladybird came up with was a special kind of a deed where a person would retain a life interest in that property, which means that person that owns the property has a life estate, can live there for as long as he or she lives. And then we actually put where the remainder goes upon that person's death and could go to the children. And that's one way to avoid probate for the house. It's not the best way because, say, one of the children ends up dying and the deed's never changed, and we still got a probate on the house. If we just deed the property into the living trust, we always have a backup plan.
That makes sense.
So if this person dies, who gets that share? Their children, the other siblings or whatever. We always have a backup plan. But what's nice about the Ladybird deed is that if she goes ahead and creates that Ladybird deed, and she retains rights to where she can actually do what she wants with the property, and it doesn't take the children or whoever else is on that deed in order to convey the property. So she still retains the right to sell, right to do anything she wants.
And can she change the person who receives it, the beneficiary?
She can even change that, sure.
Okay. Man, reminds me of our days when we were in real property together, talking about contingent remainders and all that. See, law, even though we do one area of law, they always seem to combine with each other. And so this is probate, but it's real property just as much.
It is.
Yeah, so that's very interesting. And look, I had two of the same questions on Ladybird deeds.
Yeah,
so,
that terminology is floating out there more and more. I always get questions on, can you do a Ladybird deed for me?
Yeah, and you've answered this part of it. Would a living trust offer any additional benefits in this type of situation?
Yeah, what we just talked about is
exactly
that you always have a contingency plan if somebody passes away, what happens to that share?
So I think so. The trust always seems to be the way to
It
go.
always comes back to that. It's the
Yeah.
best way, and for not a lot of money, a lot of peace of mind, and makes everybody happy. And it's usually the children we hear from.
Right.
It's hard enough losing mom and dad, but having the living trust made it so easy.
Yeah, well, that's wonderful. Part of the estate planning also has to do with long-term care costs and nursing home costs. You see that a lot?
Oh, yeah, that's probably the number one question I get.
Yeah. So what can people do?
I always get the question, should I start giving my assets away? Well, I don't.
Why would they do that?
Well, because there's going to be a look-back period, 3 to 5 years, where if that person dies in that look-back period, they're not going to qualify for Medicaid benefits.
Okay.
So I always say, well, don't give your money away. You work too hard for it. If that time were to come where you would need a nursing home, we have special Medicaid language in our power of attorney documents that would enable the power of attorney to apply for Medicaid benefits. And in our firm, for instance, we have a Medicaid practice with an attorney that heads that up, that does nothing but protect assets, qualify people for Medicaid for nursing homes. But we don't actually do that until the decision's made that there's going to be a nursing home.
Okay.
Because hopefully there never will be. And but if there is, we can protect the assets.
Yeah, and that's what I've heard too. I think similar situations that mom or dad needs to go into a nursing home, but they have too many assets to qualify for.
And the nursing
Medicaid.
home will say spend down. Well, legally you don't have to do that.
Okay.
So you need to search around to find an elder law attorney that specializes in Medicaid.
I think that's very helpful because I think, especially in our elderly community.
You calling me elderly?
No, not you. Yeah, no. Hey, I told you how long I've known you. I can't call you elderly. But in our community, Tampa Bay, that situation's coming up a lot. Nursing homes.
A lot. You're right.
So, and we talked about the homestead exemption, how that can be protected even if you put it into a trust, even though it's not in the name of the person anymore. It still gets the same homestead exception protection, right?
Yeah, and that's the number one concern I get from people. It's, well, I'm going to lose my homestead exemption. I heard. Well, no, you heard wrong. You still keep that.
Okay, that is helpful. And what's the benefit of that for our listeners who may not?
Putting it in the trust?
Or just having a homestead exemption?
Oh, the homestead exemption reduces the taxes.
That's important.
And putting in the trust keeps it out of probate.
And talking about taxes, is there a way to minimize estate taxes or to avoid them entirely, if one way or the other, with proper estate planning?
Yeah, the estate tax exemption right now is $11 million. Most people don't have that problem right now.
Right.
But if Congress doesn't do anything next year, it's going to come down to $5 million, which is still a lot. A lot of people don't have to worry about. But if the estate's larger than that, there's certain things that we can do. We can get creative, create a trust for husband, trust for wife. It's called an AB trust, where we can actually double the estate tax exemption. There's charitable trusts, all kinds of different trusts where we can reduce or certainly eliminate the estate tax. But it takes planning.
Wow.
We got to think about these things while we're healthy, while we're still here.
My head is spinning after about an hour. And so, Dennis, I'm sure some of our listeners are spinning as well and may have more questions for you after the show ends for today. So how can they reach you if they need to get in contact with you?
Yeah, my name's Dennis Moses. I'm with the Pippin Law Group. My phone number is 727-586-3306. Extension 302.
And it's Moses, just like in the Bible. He's a great man. He's a great attorney. So I strongly encourage you, if you have questions, to contact Dennis with any questions. I'll be back next week to talk about personal injury law and Social Security disability. With this storm coming up, I encourage you to be very safe. Drive safely. Watch out for those who don't. Take care. Good night.
WTAN Clearwater
FM